May we please have appearances of counsel?
Good morning, Your Honors. My name is Robert O'Shea. I represent Ms. Morgan and James Barry, Amicus, curiae, Community Association for Justice.
Good morning, Your Honors. Lewis Smith, Greenberg Trary, appearing on behalf of respondents Sanford Brown Institute and Career Education Corporation. With me is my colleague Brian Feeney, who was admitted for a lot of these hearings.
Mark Miller on behalf of the Pacific Legal Foundation, appearing as amicus in this case.
Mr. Smith, I understand you're arguing, is that correct?
You're correct, Your Honor.
Welcome, counsel.
Thank
Mr. O'Shea, you may proceed.
May it please the court, counsel. Good morning. It's an honor to appear before the court on behalf of Ms. Morgan and Ms. Deaver. I'm here to argue essentially three things: fairness, transparency, and consequences. Ms. Deaver and Ms. Morgan entered into a unaccredited program in 2010. Before they entered into the program, they had signed an enrollment agreement, but the enrollment agreement wasn't effective until February 26, 2010, after they entered, because it wasn't countersigned by anybody from Sanford Brown Institute until it was signed approximately 5 months after they had presented their signed enrollment agreement to the recruiter. So essentially, and I hope this is not trivial because it seems to be important, they entered Sanford Brown by their actions because there was no contract at the time they started classes. They started classes in February. I've seen February 10th. I'm not sure if that's the exact date, but it was before there was an enrollment agreement. So by their actions, they created a contract by attending classes. When the contract was countersigned, only then did it become effective. We're here basically as a result of this court's important decision in Adelise to review de novo whether or not these two students were advised clearly that by signing the second page of a document, they were waiving their right to a trial. Adelise has been discussed many times by the appellate court division, and the issue of whether or not there was a meeting of the mind comes before any discussion whether or not the Federal Arbitration Act is applicable. I submit to you that it's abundantly clear that Sanford Brown Institute had an interest in curtailing the students' rights, and that their interest in curtailing the students' rights manifested itself by a completely and utterly ambiguous paper presentation to the students, which, as I said before, didn't form a contract because the contract had to be countersigned, and it wasn't countersigned until February 26, 2010. It's a completely ambiguous contract that must be read against the interests of Sanford Brown because they totally created the document. And the first reason why it's completely ambiguous and doesn't waive any statutory or trial rights is because there's a notation on the second page that my signature indicates I agree to all of the above terms. This appears in the appendix at, I believe, 38 and page 41, or around there. I can look it up. But by signing, they agreed to all of the terms above that line. And if you look above that line, there's no mention of arbitration anywhere. So a reasonable person could assume that by signing, they were agreeing to the terms above the notation. My signature indicates that I agree to all of the above terms, not to any terms. And arbitration never appears anywhere.
There is another line above the signature, the capital letters.
It's above the signature, Chief Justice, but it's not above the notation that says my signature indicates that I agree to all the above terms.
So because that sentence comes before the one in caps, we ignore the sentence in caps that precedes the signature?
Well, the standard is whether or not Sanford Brown, that wrote this document, unambiguously informed the students that they were waiving their right to trial. So that's one factor. But Chief Justice, if you look at page 4, there are many other factors that creates ambiguity.
What about the last clause, which is provides typical provision that this is the entire agreement between the parties, this contract provides the promises that both are made, etc. An integration clause. Why doesn't that at the very end of this, page 41A of the appendix, essentially tell the reader, if somebody does read all the way to the end, that this is the entire contract. This contract is our contract, and all provisions are enforceable.
Justice Patterson, these were not lawyers.
No, I understand.
And the burden is on Sanford Brown to tell the students that they're waiving their rights to a trial.
But integration clauses are enforced all the time against non-lawyers. The fact that somebody isn't an attorney reading it doesn't mean it's unenforceable, does it?
Justice Patterson, I would submit to Your Honor that what we're striving here for is transparency and fairness, and to put boilerplate language in a contract that may or may not have been shown in its entirety.
Is this the issue on which we granted cert? I'm looking at the issue, and this doesn't seem to be the heart of why I thought we took this case. So do you have the issue on which we granted cert before you?
Not before me, Your Honor.
Well, tell me if I'm mistaken. It's whether the arbitration agreement's provisions are sufficient, clear, and unambiguous to reflect the parties' mutual assent to arbitrating all disputes between the parties, waiving the plaintiff's right to assert Consumer Fraud Act claims in court, and delegating threshold arbitrability issues to an arbitrator. Is that the issue on which we granted cert? So,
and Justice Allen, that's what I'm attempting to address.
So I think we should be looking, if I'm mistaken, you can correct me, but I think we should be looking at the arbitration agreement.
You may have stronger arguments than the one you started with. Why don't you move on to those?
I do. If the court will look at page 4, which is the language of dispute resolution and arbitration, it's in very fine print, and my colleague will address that. But at first, you would have to read the agreement to submit SBI's grievance procedure. And if you go down to the 4th line, it says the student commencing arbitration or otherwise pursuing his or her claim, which would lead a reasonable person to believe that arbitration isn't the only method of resolving claims. It goes on to say, in the very next line in the middle, a court of competent jurisdiction. Again, adding ambiguity to the fact.
Wait a minute.
I'm sorry. Go ahead.
Paragraph 10, agreement to submit to SBI's grievance procedure.
Yes, Your Honor.
It says the student agrees to submit any claim, dispute, or controversy that the student may have arising out of or relating to his or her recruitment, enrollment, attendance, education, financial aid assistance, or career service assistance by SBI to SBI's grievance procedure set forth in the SBI catalog. The parties agree to participate in good faith, and then says compliance with SBI's grievance procedure is mandatory, it's underscored, and is a condition precedent, underscored, to the student commencing arbitration or otherwise pursuing his or her claim.
Yes, Your Honor.
So I'm seeming to hear, maybe I'm wrong, that you're suggesting that this is leading the student to believe that they don't know what their remedies might be?
If the student saw this, that's what I'm saying. Now, Justice Cuff, if you will look at the language that you just read, it says the grievance procedure is mandatory. It doesn't say arbitration is mandatory.
Well, it says that this is a condition precedent to the student commencing arbitration or otherwise pursuing his or her claim. And then we go down to agreement to arbitrate.
Well, I hope we don't go down there yet, because I wanted to point out that the very next line says a court of competent jurisdiction. A court of competent jurisdiction is not arbitration. So first you have the line that was put in there by SBI saying the student can commence arbitration or otherwise pursue his or her claim.
Look what this court is doing. This hypothetical court of competent jurisdiction is not deciding the ultimate substantive claim. It says, notwithstanding the preceding sequence, if a statute or other legal authority specifically bars SBI from requiring the student to utilize SBI's grievance procedure, and here comes the court, or a court of competent jurisdiction determines that such a requirement is unenforceable with regard to the student, then that sentence is severed. Mm-hmm. That's where the court of competent jurisdiction has a role, and that's determining the enforceability of the student grievance procedure, isn't it?
Well, I'm an attorney, and I've analyzed this over and over again, grammatically and otherwise. You'd have to be a grammatician to understand that insertion in this of the phrase a court of competent jurisdiction doesn't create ambiguity.
Why don't we jump to the heart of it?
Mm-hmm.
It's about, I don't know, a dozen lines or so down, agreement to arbitrate. And here's what I see, and I want you to tell me if there's more to it. Any disputes, claims, or controversies, and I'm going to skip down 1, 2, 3, 4 lines, shall be resolved pursuant to this paragraph. And then it lays out a number of different things. Does it say anywhere in the paragraph that disputes are to be resolved by arbitration instead of in a court of law? Does it use that language?
Not that I saw, Your Honor.
Yeah. What do you make of that?
What I make of that is that students were being asked to sign documents that pages later, and on the page they signed, didn't inform the student that they were giving up their right to trial. And
is there any difference between this arbitration agreement and the one in Adelaide's? Have you read them side by side to see if there's any difference between them, other than the fact that this arbitration agreement is longer?
Justice Alvin, I think they're the same. I think Adelaide's has to apply to this case for the reason that the public is entitled to have clear, predictable, and fair application of law. And the law of this land, which hasn't been disturbed by the Supreme Court of the United States, is that people that are signing agreements must be informed specifically that they're waiving their right to a trial and statutory
Right, I
remedy.
understand that. Is there is there anything distinguishable between the arbitration agreement in Adelise, which we struck down, and the one here?
I think they're the same.
Well, what about the rent-a-center case? Let's get to the argument that's being advanced by your adversaries. They say rent-a-center raises an issue as to whether or not your clients needed to object specifically to whether the question of arbitrability gets decided by the arbitrator or can be decided by a court of competent jurisdiction. Under their reading of rent-a-center, they say this agreement clearly goes to an arbitrator. You have arguments on the other side of that position. I'd like you to, if you could, help us with that, because that does encompass some of your ambiguity arguments, but it gets us more directly to the point of this appeal.
Yes. I see this whole issue as an onion, and at the core of the onion is whether or not there really was a meeting of the mind.
On what? On what?
On whether or not the students were waiving their right to a trial.
That's not the issue.
Rent-a-center says you have to show that there was a meeting of the mind on submitting questions of arbitrability to an arbitrator. Can you dispute that there was or was not? Can you show that there was or was not a meeting of the mind on that specific point?
I believe so. Now, I would go back to, I'm not entirely understanding Your Honor's question, but I'm going to answer it to the best as I can, and please redirect me if I'm not answering directly your question. Even the Federal Arbitration Act, in Section 4, says that the judge, and in this case it's talking about a federal judge, must first determine whether or not there was an agreement to arbitrate. So even the federal statute says the core issue is, was there an agreement? And under New Jersey law, there was no agreement. But let's say there was an agreement. The agreement to arbitrate has been contested at every level. And actually it was contested before the appellate division stronger than it was here.
If I can, may I follow up?
Sure.
Yeah. Do you understand that the issue that is being raised by the defendants is the delegation clause? The core issue is the delegation clause, which was not present in Adelise and is present here. And let me start from square one. Do you contest the applicability of the Federal Arbitration Act?
No.
You don't? Okay, so we're in...
Not if there was an agreement to arbitrate. So, I don't contest the fact that this involves interstate commerce.
Okay.
But I do say there was never an agreement.
Okay. Am I correct that the issue, one of the key issues between you and your adversaries, is whether the delegation clause, which states that the issue of arbitrability goes to an arbitrator as opposed to a court, whether that is enforceable in this case? Am I correct just stating the issue? That's one of the issues between you and your adversary.
That's one of the issues they raise,
Okay.
yes.
And that raises a different issue than Adelise, am I correct? That was not part of Adelise.
That would be a secondary issue if Adelise didn't control in my opinion, Justice Patterson, if Adelise didn't control the fact that there was no agreement.
Okay. But is it fair to state that we have a question here as to who, a court or an arbitrator, should make a decision about whether the case is subject to arbitration?
I don't agree with that. And that's because of the federal, even the Federal Arbitration Act says the judge must make the initial determination about whether there was an agreement.
Is your, I'm
Is-
trying, I'm trying to
can we-
get the heart.
I'm sorry, if I could.
Are you arguing with respect to the delegation clause, that the delegation clause can't be applicable because there was no meeting of the minds to delegate to an arbitrator because your clients were not told about the fact that arbitration is something different than going to court?
Yes, Justice Alba,
So you're saying that goes to the delegation clause as well?
yes, it goes to the whole
Formation of the contract, even the
formation of the contract. You can't not have a contract and then agree to delegate issues that are not even in arbitration.
So your position is that when we're talking about formation, you're going to the very contract itself,
Correct.
not a provision within the contract.
Correct.
The provision in the contract seems, under the arbitration agreement, seems under Section 5 or subsection 5 to contain a delegation clause that would include any objection to arbitrability or the existence, scope, validity, construction, or enforcement of this arbitration agreement. But you're saying we never get there because there is not an enforceable contract. Is that your position?
Yes, Justice Cuff, because how can you contest a delegation clause if you haven't even agreed to arbitration? The matter is in front of the Court of Common, in front of the court. If you go back to the initial pleadings, Morgan and Deaver never requested a rescission of the contract. What they did was they enrolled in SBI, and they never knew that they were required to arbitrate.
But doesn't Rent-A-Center, isn't Rent-A-Center in the middle of that? I mean, didn't the Supreme Court say that if there's a fight over whether there is an enforceable agreement to arbitrate, you get your fight. You get to fight it out, but it goes to the arbitrator. That's under the FAA. In other words, Rent-A-Center doesn't say you don't get to make this argument, but Rent-A-Center says who you get to make the argument to. Isn't that a fair statement about Rent-A-Center?
I would agree with Your Honor because Your Honor is making this statement, but...
No, I'm just asking, it's a question. Am I correct that Rent-A-Center says if you have a fight, such as the fight you have framed here today, which is whether this was an enforceable agreement, you take that fight not to a court, according to Rent-A-Center, but to an arbitrator. We can argue whether that's good policy or not, but that seems to be what the Supreme Court is saying.
That is a fundamentally harmful policy, in my view, because...
Okay, we can argue policy, but my question is that what the United States Supreme Court in interpreting federal law is saying?
I don't think so, because the cases that I've read about arbitration says you can't have an arbitration unless people agree to an arbitration. And particularly in this particular case, Justice Patterson, if I may, here we're talking about a for-profit industry that educates people in unaccredited programs.
And I don't mean to cut you off at all, because I understand you're making a policy argument, but would you agree that there's interstate commerce involved?
Yes.
And I think you'd agree with the general proposition that when there's an issue of federal court, if in fact the United States Supreme Court has interpreted that, then this court has to defer to that. Am I correct about that?
No.
No?
I don't think that Rent-A-Center is that close to this case.
Okay, we'll get to that in a second.
Okay.
But do you agree with me that if there is, the United States Supreme Court speaks to an issue interpreting congressional legislative intent on an issue of federal law, then this court and all state courts have to defer to that? United States Supreme Court, not a circuit court.
I would agree with that.
Okay. So, let's talk about Rent-A-Center.
Okay.
Why is it that you don't see Rent-A-Center as affecting the issue of who determines the question of arbitrability that you have been pressing here?
Okay. The first reason is the one that I've stated ad nauseum, and that is because the issue is addressed in the Federal Act, Arbitration Act. I want to grab something.
Did you challenge the delegation clause?
Did we challenge the delegation clause? In a general way, because we challenged the arbitration clause. You know, that's the best I can give
Because
you.
that seems to be the exception, because if you challenged it, according to Rent-A-Center, then the validity goes to the court.
Well-
I'm reading from the opinion. Accordingly, unless Jackson challenged the delegation provision specifically, we must treat it as valid under Section 2, the arbitrate, and must enforce it under 3 and 4, leaving any challenge to the validity of the agreement as a whole to the arbitrator.
Mr. O'Shea, I know you seem to have great reluctance to agree that Rent-A-Center completely controls this case. Is in part your reluctance based upon the difference in language between the delegation clause in Rent-A-Center and the delegation clause that appears in part of this overall paragraph number 10, and it's part of the all one paragraph, but the agreement to arbitrate under the Roman numeral 5 language, which reads, I think Judge Cuff read it before, any objection to arbitrability or the existence, scope, validity, construction, or enforcement of this arbitration agreement shall be resolved pursuant to this paragraph. That language is markedly different from the language that appeared in Rent-A-Center, that the Rent-A-Center court found clear and unmistakable. That language said, the arbitrator and not any federal, state, or local court or agency shall have exclusive authority to resolve any dispute relating to the interpretation, applicability, enforceability, or formation of this agreement, including but not limited to any claim that all or any part of this agreement is void or voidable. You've been harping on the ambiguity that you see throughout paragraph 10.
Yes.
Am I interpreting your argument, am I inferring from your argument that through this different language in what's designated as Roman numeral 5, buried in this long paragraph 10, does not evince the clear and unmistakable requirement that the court found apparent in Rent-A-Center, and therefore your case is different than Rent-A-Center?
Yes, Your Honor, that's exactly what I've been struggling to say, although Your Honor put it much better than I would have been able to do if I'd been here for a couple hours. The fact that they say that this gets resolved pursuant to this paragraph is very circular. You'd have to be a lawyer to understand that. And so none of the waivers that SBI seeks to enforce on the student is clear at all from the document, which they created, and created with the motivation of having students waive rights and go to arbitration, which I don't know if we can take notice of the New York Times series, but arbitration favors companies like SBI.
But the language that was just read to you by Justice Lavecchia is the very type of language we suggested in Adelies needs to be in an arbitration agreement. Right? It's an explanation that the arbitrator and not any federal, state, or local court, telling the difference between what arbitration is and a judicial forum. Right?
Yes.
Are you following me?
Yes, but what we're talking about is statutory rights and a right to a trial. And this has to be clearly stated to people before they can waive these rights. This is not a knowing waiver of the right to have the issue decided by the court, because it says shall be decided according to this paragraph, which tells somebody who's reading this once or never at all nothing. This is a very ambiguous statement, and what it does is it takes controversies that are very important to the public, for-profit organizations offering students courses that are unaccredited for $37,000, over $37,000. These issues need to be decided in a public forum for transparency, so that the public has a knowledge of the working of the law.
But we have no antipathy to arbitration. Arbitration is a fine way to resolve disputes, and your adversaries are saying we should not be putting up, unsurpassable hurdles or any hurdles that are unique to arbitration. So tell us why you think this language in Roman numeral 5 specifically doesn't, even though it's different, doesn't satisfy the clear and unmistakable standard that Justice Scalia spoke of in the Rent-A-Center case. It may be different, but nevertheless, does it meet it?
I would point, Your Honor, to the portion where it says shall be resolved pursuant to this paragraph, which really doesn't tell the reader anything. It's subject to interpretation. Certainly the lawyers that created this language interpreted it one way. Their interpretation is their own interpretation. It really doesn't specifically state who's going to resolve this issue. It just says is going to be resolved according to this paragraph. And we're talking about a very important issue here. So although we have no antipathy to arbitration, arbitration is not a good forum, because arbitration is behind closed doors, and it's not a public.
That's not I think this is what Justice Levesque is saying. That's not the issue before us.
I think we have your position on the core issue. Is there anything you wanted to say in summing up?
Yes, I do. What are the consequences of the court's decision? If the court applies Adelise and finds de novo that there's no meeting of the minds, the parties will only have been sent to arbitration if they really agreed to arbitration. On the other hand, if the court doesn't vacate the appellate division opinion, this sets out a roadmap for other for-profit institutions who want to maximize their profit by denying their students the right to have their claims heard in court in a public forum, and also who seek statutory damages.
Thank you, Mr. O'Shea.
Thank you.
Mr. Barry.
Good morning. The analysis that this court has to undergo in determining whether or not the question of arbitrability is delegated to the arbitrator in this case is actually a two-part analysis. The first is a question of whether the contract for arbitration was formed applying state law and Adelise. And then the second, if that question is answered in the affirmative, that an arbitration agreement, including the delegation clause in this case, was properly formed, whether or not that delegation clause clearly and unmistakably delegates the question of arbitrability to the arbitrator. On behalf of the New Jersey Association for Justice, we assert that under federal and state law, the answer to both questions is in the negative. First, if I may address some of the questions that were posed to preceding counsel, the threshold question in this case is whether or not a contract was formed to arbitration. If you look to First Options of Chicago versus Kaplan at page 944, they clearly state when deciding whether the parties agreed to arbitrate a certain matter, including arbitrability, courts generally, though with the qualification we discussed below, should apply ordinary state law principles that govern the formation of contracts.
But can I ask you a question about that? Because it's obviously this is very, very potentially confusing material. If, in fact, let's assume both of your questions, not in this case, but both of your questions are answered in the affirmative, and arbitrability goes to the arbitrator, what is that question? Isn't that the question whether the substantive matter is subject to arbitration?
The scope of the arbitration agreement would be a question that would be posed to the arbitrator. However, the formation of the contract is never a question that should be sent to the arbitrator.
Okay, but if you have, in fact, you're saying that there is a state law question up front as to whether the particular matter, there was an agreement by the parties to arbitrate the substantive issue. In this case, let's say it's whether or not there was a consumer fraud with respect to what the school could offer the students. Okay, so you're saying that's a matter of state law. That's decided up front. Okay, let's play this out. Assume, I'm not talking about this case, assume the answer is yes on that. We go then to the question of whether there is a clear and unmistakable agreement to submit the question of arbitrability to the arbitrator. And let's say the answer to that is yes, as in Rent-A-Center. Then aren't we saying, under your analysis, that the arbitrator is going to decide the very same question under the federal arbitration law as you've indicated is dealt with by state law, and that is the question of whether the subject matter has been agreed upon to be arbitrated. You see what I'm saying?
The question is slightly different. The question is whether a contract agreeing to arbitrate was formed. The arbitrator is then allowed to address the scope of the arbitration agreement, and the question is not for the court how wide was the arbitration agreement. It simply was an arbitration agreement formed, and was there a clear and unmistakable delegation of the arbitrability question.
Okay, so let's continue with this for a moment if we could. Let's say one side says nothing, I had no agreement to arbitrate. I didn't agree to anything. The issue here is I never agreed. The other side says yes. That question of arbitrability that goes to the arbitrator, assuming that your two questions are answered in the affirmative, is what? It's whether the parties agreed to arbitrate that matter.
The question posed is actually a question of formation. If one party disputes that a contract was ever entered into, that is a question of formation for the court.
But formation, are we talking about a broader question of whether there's a contract or an meeting of the minds and an agreement to arbitrate a particular substantive matter?
The challenge can be both to the question of whether a contract as a whole was ever formed, or whether the arbitrability or arbitration agreement was ever formed.
Which just takes me back to my same question. Isn't there a repetition under your formulation of how this works, where state law, there's a judicial determination up front of a question of whether there was a meetings of the minds to arbitrate a particular dispute, and then under Rent-A-Center, assuming the answer is yes, the arbitrator determines whether there's a meeting of minds as to whether there's an agreement to arbitrate the dispute.
The only dispute, the question is whether there was a contract formed for arbitration. It's not about whether the parties agreed to arbitrate a specific breach of contract claim. The question is whether an arbitration agreement was formed and whether that arbitration agreement had a clear and unmistakable delegation of arbitrability.
So even if it was formed, because Rent-A-Center dealt with whether or not the contract was unconscionable. So I suppose that theoretically the contract can be formed, there could be a meeting of the minds, but yet it can still be unconscionable. And under this delegation clause, then, if there was a meeting of the minds, then if the delegation clause hasn't been challenged, then the arbitrator can determine whether or not it's unconscionable.
Correct, and that's actually a distinction that the court had in Rent-A-Center. If you look to footnote 2, they specifically held in Rent-A-Center they were not determining a question of contract formation. I can quote to the court, the issue of the agreement's validity is different from the issue of whether any agreement between the parties was ever concluded, and as in Buckeye versus check cashing, we address only the former.
So you think that the court was making that distinction between formation and it still might be not valid because it was unconscionable.
Absolutely. And if you go to Buckeye, Buckeye actually cites a number of cases, including Sandvik versus Advent International Corp, a Third Circuit opinion from 2000, where the court actually made the initial decision as to whether a signer lacked authority to commit the alleged principal to an arbitration clause. The court found that the question of whether authority, that a signer had authority to bind a principal was a question for the court. It was not an arbitrability question. for the
Isn't that
arbitrator.
also at the very end of footnote 1, where the court is explaining that the validity of a written agreement to arbitrate, whether it's legally binding as opposed to whether it was in fact agreed to, the latter part including unconscionability concerns. The first part, whether it's legally binding, is governed by Section 2 and does go to a court.
Correct. There's a distinction about whether a contract in Rent-A-Center, there's no dispute that there was a contract entered into and that there was a clear and unmistakable delegation of the arbitrability question
Correct.
to the arbitrator.
Correct.
The question was instead whether the contract was revocable because it was unconscionable.
Right.
That's different from the question of whether or not an agreement was ever entered into between the parties.
So what do we do when we have a disagreement over whether there was a contract ever agreed to initially? And there is also, let's assume for purposes of our discussion right now, a clear and unmistakable delegation clause.
The question of the contract formation has to be decided by the court before determining whether or not to delegate, to send it to the arbitrator.
And then to take it to the next stage, what is left, just in that hypothetical, what's left for the arbitrator to decide?
What would be left for the arbitrator would be challenges to the contract based on, as was the case in Rent-A-Center, unconscionability, as was the case, or fraud in the inducement of the contract. Cases where you have an agreement that there was a contract entered into between the parties, but there's a challenge to whether or not the contract is valid.
And also, for instance, this arbitration agreement does away with the Consumer Fraud Act's treble damages provision, the fee shifting provision. Assuming the formation of a contract, the arbitrator would get to decide those factors as well.
Correct.
Am I mistaken?
You're not mistaken. That would be if there was a valid arbitration clause and a valid delegate. If the contract was formed and there was a valid delegation, then that we would concede would have to go to the
And
arbitrator.
a challenge to a provision, for example, as Justice Alvin mentioned, based upon a public policy challenge, that would go to the arbitrator under Rent-A-Center.
So long as it didn't involve the actual formation of the contract. In the abstract, it's hard to think of a public policy argument on my feet about that would affect whether a contract was formed. Perhaps if somebody lacked the mental capacity to enter into a contract, that
Or
would be a
that
public policy issue.
that a contract is formed, but that its object is contrary to public policy. It vitiates some important public policy of the state, and that might be an argument. That argument would go to the arbitrator.
Correct.
And didn't Justice Alvin just give you that example, the Consumer Fraud Act? It's an issue of public policy. The limitations on it, is that something the arbitrator would decide as a matter of public policy, or would that, notwithstanding, let's say, the enforceability of the arbitration clause, is that a separate issue that would have to be decided by a court?
It pains me to say this, Justice Solomon, but as the law of Rent-A-Center stands, that challenge to the enforceability of the agreement would, under Justice Scalia's opinion, have to go to the arbitrator.
But it might eventually get back to a court because of the arbitrator's interpretation of the law was not reasonably debatable. Then eventually that comes before a court. It's just the question of how it gets to the court.
Correct. You
right?
may have a Section 9 challenge at some later date as to the enforceability of an arbitrator's award.
Mm-hmm.
Anything you'd like to add, Mr. Becker?
If I may just briefly, I move through the, I don't think that there's a real argument that this contract satisfies the Adelaide standards about whether or not it explains to the students what the agreement to arbitrate is. It never mentions the right to a jury trial. The only time that it mentions a court is in saying that a court may hear a dispute about the grievance process that the agreement has in it, and it has a vague reference to the other tribunal competent jurisdiction who may make a ruling on the validity of the contract.
What about the latter portion of paragraph 10? It's all one paragraph since it's all called 10. that specifically says there shall be no right, this is under class or consolidated action. The contract felt the need to put in here expressly that there shall be no right or authority for any claims within the scope of this arbitration agreement to be arbitrated or litigated in a class basis, or for claims of more than one student to be arbitrated or litigated jointly or consolidated with any other student's claims. Does that add to the ambiguity, or is it fair to say that that provision adds to the ambiguity, that there are some things that might have been going to courts that the agreement had to deal with expressly?
It may add to the ambiguity of whether or not a court has the right to decide certain issues. Again, while it pains me to say it, I think the Italian Colors case has decided on the validity of class waivers for the time being.
The question is not whether there's a class waiver or not, but a layperson reading this agreement would say they're still talking in the agreement about actions that can go to a court.
Correct.
And that are being specifically carved out. So what's left that can still go to a court?
Correct.
And doesn't the severability and right to waive provision also reinforce that ambiguity, that there might still be a role for a court to make certain foundational decisions?
That was correct. That was my reference to a tribunal of
Competent jurisdiction, right.
If I may move briefly to the question of the delegation clause, if the court finds that a valid contract to arbitrate claims was formed, then the question becomes whether there's a clear and unmistakable delegation of the arbitrability question. That's when the first options and Rent-A-Center standard comes in, with heightened judicial standard under the federal law. And what that really means is that if there's ambiguity or silence on the question of arbitrability, even the United States Supreme Court says you cannot interpret that in favor of delegating this issue to an arbitrator. It has to go to the court if there's any ambiguity. In the opposition to our amicus brief, defendant raised the issue of whether the reference to the AAA rules was enough to delegate this issue of arbitrability to the arbitrator. And I simply wanted to point out first that it's not simply a reference to the AAA rules. The contract also supplies that you may go to the NAF under the NAF rules, except the NAF, after I believe it was 2010, no longer hears consumer disputes due to a settlement with the Minnesota Attorney General due to corruption and fraud, where they had common ownership with a number of debt collectors. And under first options, you can also take into account, when seeing if there's a clear and unmistakable delegation, you take into account the conduct of the parties. In first options, the parties appeared in the arbitration setting because the Kaplans were actually owners of another party, another entity that did agree to arbitration, but they challenged the arbitration agreement throughout, and the court actually reversed an award under Section 9 of the FAA, saying that it was enough that they had lodged the complaint throughout the arbitration process, and that the arbitrability question was not clear and unmistakable to the arbitrator.
I'm not asking you as to what happened here, because you're representing amicus, not a party, but would you agree that Rent-A-Center provides that if there's a general challenge to an arbitration agreement but no specific challenge to the delegation clause, then that issue is waived?
With the caveat that it doesn't apply to formation of an arbitration agreement, I believe that argument goes to both arbitrability and the arbitration agreement. I would agree that Justice Scalia wrote that the arbitrability issue is one that should be severed from the rest of the agreement and determined on its own.
And then it's the obligation of the party challenging the agreement to challenge the arbitrability, the delegation clause specifically.
Correct.
Yeah.
Do you take that position because in Rent-A-Center, factually, there was no disagreement about there being a binding agreement?
That's true. There was no dispute at all whether there was a clear and unmistakable delegation. And the clause was actually very clear about what exactly the parties were agreeing to delegate to the arbitrator, referencing both court actions and rights to jury trials.
Thank you, Mr. Barrett.
Thank you.
Mr. Smith.
May it please the Court, the Appellate Division's decision compelling arbitration in this case should be affirmed. First, Appellate Division found that the Federal Arbitration Act applied and controlled here. That's not disputed by anybody. It's in the agreement. It clearly involves interstate commerce. You have New Jersey students attending a campus in Pennsylvania. Second, the Appellate Division properly found that the parties clearly and unmistakably agreed that an arbitrator would decide issues of arbitrability. The language here in this clause is not identical to the language in Rent-A-Center, but there's no meaningful distinction in terms of conveying that the parties clearly and unmistakably agreed that arbitrability would be decided by the arbitrator. Third, the Appellate Division properly found that there was never a specific attack on the delegation clause by the plaintiff. It wasn't at the trial court, wasn't at the Appellate Division, and no such attack was made in the petition for certification that was submitted by the plaintiff in this case. And this is significant. The reason why the Supreme Court has this rule that you specifically have to attack the delegation clause relates to severability and the way attacks of contracts containing arbitration provisions are addressed. If there is an attack on the agreement as a whole under long-settled federal law, that is an issue that goes to the arbitrator. If there is traditionally an attack directed towards the arbitration clause, traditionally that would go to a court unless the parties agree otherwise. And we are in a case of the unless. And here the parties have agreed otherwise. So amicus counsel indicated that this was a two-step process. You have to look at contract formation first. The Supreme Court in its jurisprudence has severed this analysis and severed it to where the focus here is on the delegation clause and whether in that delegation clause did it clearly and unmistakably provide that the arbitrator would deal with these issues, which the Appellate Division properly found was the case, and therefore properly ruled that all of these objections will go to the arbitrator for disposition. The requirements of this court's opinion in Adelise versus U.S. Legal Services cannot be applied to the delegation clause. Again, the analysis has to specifically focus on the delegation clause, and the Adelise scrutiny cannot be imposed on it. First, it wasn't raised by the petitioner in any timely manner. Second, federal law precludes it. In Rent-A-Center, the Supreme Court clearly announced that the party's manifestation of intent and not the agreement's validity is what controls. And in Adelise, the concern of the court was with validity. Will this agreement be enforced? Is this legally binding language that was put into an agreement to allow it to be enforced? That was essentially the approach that was taken by the Ninth Circuit that was reversed in Adelise, and it is the position that's advocated by the dissenting justice in Rent-A-Center. Essentially that you need to look at state law contract formation principles to even find out whether or not there's an enforceable delegation provision. That was expressly addressed, and it was expressly rejected. And the inquiry instead, per Rent-A-Center and Justice Scalia's opinion, says you focus on manifestation of intent, meaning the language of the agreement, and you do not take the next step and determine whether or not it is valid. That's going to be something that can be pursued in front of the arbitrator in the event that there's clear and unmistakable language that will go to support the delegation provision.
Are you done with your opening statement?
If I could make one more
Sure.
point.
I'm sorry, I don't want to interrupt you.
Thank you, Your Honor. And I would submit, even if your honors conclude differently, that you feel there is a place for state law to address a delegation clause, I would suggest to your honors not to extend the Adelise decision beyond where it currently sits. That was a case that involved two statutory claims and whether or not the language was sufficient so that a consumer would be found to have waived the right to have the merits of the claim determined by a judge or a jury. Here, what we're talking about is a threshold legal issue. So any concern about a jury is not present here. It's a threshold legal issue, and it's not going to the merits of the dispute. It is focused on, as we must, under Rent-A-Center and the severability analysis, we must focus on the delegation clause, and it does not raise the same concerns that I believe were raised in Attlee's about ultimate disposition of the claim. It is simply a threshold legal issue.
Are you finished?
Yes, Your Honor.
Thank you. Mr. Smith, you point to the language of manifestation of intent, and it certainly caught my attention as well. I'm trying to puzzle through and clearly understand Justice Scalia's opinion, and I keep coming back to this extended explanation in footnote 1, where he is using the language that you referred to. This is after he's already acknowledged what the parties have agreed is not in dispute with respect to the specific language of this arbitration agreement in Rent-A-Center. But then further down in that same footnote, and I asked your adversaries the same question, after the court cites the AT&T Technologies case, he writes, the validity of a written agreement to arbitrate, and with the parenthetical, whether it is legally binding as opposed to whether it was in fact agreed to, the latter now including, of course, his language, whether it was void for unconscionability, close paren, is governed by Sections 2 provision that it shall be valid save upon such grounds as exist in law or equity, citing the FAA standard that brings it back to state law. So this manifestation of intent goes to the interpretation of the arbitrability provision, but I'm reading that last sentence, or second or third to last sentence of the footnote, as clearly leaving open for courts to determine whether or not we have overall a legally binding arbitration agreement. Am I misreading that footnote based upon how you would like this court to understand Rent-A-Center?
Respectfully, I believe you are, and I think it was just at the conclusion of Your Honor's remarks that it's leaving it open, not for a court, but for the arbitrator. So the inquiry is manifestation of intent. That's the court's function when there's a delegation clause. The court's role is to look at the manifestation of intent and determine whether there is clear and unmistakable evidence of an agreement to arbitrate arbitrability or gateway issues. Once you're past that, assuming the answer is yes, the matter goes to the arbitrator, and then the question of validity, like Attlee's or any of the other objections that the plaintiffs in this case may raise, can be presented to the arbitrator.
But I thought the whole point of this opinion was that those remedies in Section 3 and 4 remain remedies for a court to use. Are we in the trees so much that we're losing sight of the forest?
I think that, Your Honor, my view of the opinion is that the court's role is to focus its inquiry on the text of the delegation clause. If it clearly and unmistakably evidences an intent to arbitrate.
But there has to be an agreement, right? And that's why we go back to footnote 2 as well. Right. So yes. let's look at footnote 2 and tease it out. I'll read it and then I'll ask you a question based upon my reading.
Okay.
It says the issue of the agreement's validity is different from the issue whether any agreement between the parties was ever concluded. And as in Buckeye, we address only the former. So the latter is whether the parties ever concluded the agreement, and to me that strikes me as whether or not there was ever the formation of an agreement. So my question too, if there was never the formation of an agreement, how could there be a delegation to an arbitrator?
Your Honor, I would submit that the arguments relating to overall contract formation, it's well settled under federal law. If you just come in and challenge fraud of the inducement contract formation, that routinely goes to the arbitrator, because again it goes back to the court's view of severability.
So what this is concluded, if there was no meeting of the minds, let's take it at that, the most basic contract principle. Does that mean, would that go to the part that an agreement was never concluded? Would you say that that is fair?
I would say that in the context of a delegation clause and under rent-a-center, any such argument has got to be directed specifically. Again, this goes back to why the court thought it was very significant that the argument wasn't directed specifically at the delegation
What
clause.
does, okay, I'm going to press you on this. What does that language mean? Whether any agreement between the parties was ever concluded. Tell me what your interpretation of that language is. That's Scalia's language.
Yeah.
What do you mean by that?
Your Honor, I would submit that if he could be talking about a situation where if somebody is coming in with a document that a signature is denied, that it's just completely fraudulent on its face, that there's any sort of
That someone
agreement that's not-
who was incompetent to sign an agreement didn't sign it or something like that?
There could be scenarios like that where you're talking about it, but the general way these cases work is that if you have, as in this case, right, there's no denial that the parties in this case signed these agreements. It's their signature on the agreement, right? So we're not talking about...
Yeah, but if it was in Chinese, would you say there was an agreement? And if they only spoke English? So what would a signature mean?
A signature in this case means that...
And that's what they're claiming. This is Chinese to them, okay? Or some foreign language, because you haven't taken the time to do the simple thing that Alice said. You just have to explain that arbitration means you're not going to a judicial forum, whether it's trial or whatever.
But application of Adelaide in the context of this delegation clause would require the insertion of that, because again, the scrutiny must be at the level of the delegation clause. That's where you're looking at.
Well, Adelaide spoke, because we're talking about formation of contract, was talking about formation of contract. The whole section, an agreement to arbitrate like any other contract must be the product of mutual assent as determined under customary principles of contract law. It's in a whole section on that people have to understand what they're signing. And if they don't understand what they're signing, there can't be mutual assent, right? Am I correctly interpreting Adelaide?
Well, it's Your Honor's opinion. So
Yeah.
but the difference in this case...
I might not be, I could be misinterpreting my opinion. I hope not.
Your Honor, the difference in this case is we have a delegation clause, and that makes all the difference. And so you
But
have
even-
to...
even
There's
the
always a delegation clause. There's always a delegation clause.
I'm really having trouble wrapping my head around this. The delegation clause is part of an arbitration agreement, is it not?
Correct.
If you don't, it's a paragraph, it's a section, like every other part of the agreement. If you don't have an agreement, you don't have a delegation clause, do you?
Again,
You're saying you do.
I'm saying that the way the
Let
analysis
me
works
ask,
is...
okay, I got you.
is
Let me ask my
severability.
follow-up question. An arbitration agreement, if there's an agreement, requires that the parties give up a right that they have under our Constitution to a trial, correct?
Well, that's how things have been interpreted.
Is that yes
in
or no?
courts here. That
You're going to give me a yes on that one?
Adelaide would stand for that proposition, yes.
I take that as a yes. Okay,
Yes.
so they have that
Yes.
right.
The only reason I hesitate, Your Honor, is because there is another view that's been argued.
I don't care. I care about Adelaide. You have that right. I don't care what that other view is. All right, you have that right. You're entering into an agreement to give up that right, and you're saying the decision to determine whether you've given up that constitutional right to a jury trial, to a trial, is decided by an arbitrator? That's your argument.
My argument, Your Honor, is that if this is
Sounds like a
controlled by
yes
the
or no.
FAA, and if you have a delegation clause that's clearly and
Your
unmistakably...
answer is yes.
Yes. It's decided
Shouldn't
by-
we pay attention? Am I correct that Rent-A-Center, there was no question of overall contract formation? That
It-
was a given. I mean, Justice Scalia started at a particular point, and at that
Correct.
point, he was already on at least second base in the rounding the bases of getting to a binding agreement, and that is there was no dispute there was an agreement between the parties overall.
Correct, Your Honor.
Okay. And there was no dispute that there was an agreement by the parties to have some level of arbitration
That is correct
of
as
some
well.
things.
Correct.
Just put it in very simple language.
Correct.
Okay. So can we read Rent-A-Center to leave, especially when you look at the particularly footnote 2, can we read Rent-A-Center to leave open the issues that were already resolved by stipulation of the parties, it seems, in the Rent-A-Center case? And that is, there was a contract and there was an agreement to arbitrate some aspects of the parties' dispute.
No, because, Your Honor, Rent-A-Center, again, it takes this severability analysis one step further, and it requires the scrutiny, focus on the delegation clause, and arguments that challenge the enforcement of the delegation clause have to be targeted to the delegation clause. So if there's general overall objections to contract formation and the like, it's not going to prevent the enforcement of the delegation provision.
But that comment is made in the context of a situation where there was no dispute, there was a contract. Am I right about that?
It's true in that case there wasn't a dispute about the contract, but it's an extension of the Supreme Court jurisprudence in this area that deals with severability and how, when you look at an attack on a contract versus an attack on an arbitration clause, and now an attack on a delegation provision. So it's not, yes, it wasn't specifically in dispute in that case, but I don't think it's meaningful to interfere with the proposition that when you have a clear delegation clause, you have to focus your inquiry on the delegation clause.
So look at
and that's where
Rent-A-Center's
arguments have to come.
delegation clause, and then look at the delegation clause here. So the delegation clause in Rent-A-Center was the arbitrator and not any federal, state, or local court or agency. I mean, that is making actually a distinction and entering into the equation some judicial forum. Where is that in your arbitration agreement?
It does. It's not in the arbitration agreement. It does mention that in Rent-A-Center. I don't think it's critical for the holding. This arbitration agreement.
And my next question is, what is the difference between your arbitration agreement and the Adelise arbitration agreement, other than the fact that your arbitration agreement is longer? Is there any?
Many differences.
Go ahead.
So there's the delegation clause, which we think is dispositive of this dispute, and the appellate division analyzed the issue correctly. There is a much broader arbitration agreement, assuming the court's going to address the Adelise issue. There was a much broader arbitration provision here.
Well, there are more things that take away rights from the consumer, but is there any mention in your longer arbitration agreement that the consumer here, the students, are giving up their right to pursue a claim in some judicial forum, either before a jury, a judge, or anything like that?
It indicates that it draws the distinction between court proceedings and arbitration by explaining that, this is going to be administered by the AAA, the American Arbitration Association. Gives a website, gives a phone number, says the rules of the arbitration procedure are available at the school.
This goes back to what we discussed in Adelise. It's an assumption that the average consumer knows that, like, arbitration means I'm not going to be able to go to court. In New Jersey we have non-binding arbitration. People get trials de novo within our court system. You can call it mediation, non-binding arbitration. And someone who is familiar with that, looking at this particular arbitration clause, might think, oh, I have arbitration, but I still get to go before a court, unless there's some basic, simple, minimal explanation.
We think that it does provide that explanation, and by referring directly to where you get additional information on the process, the procedures, that'll provide.
You think that's good? I'll give you a website here. When they're signing it, do you think they have their computer with them?
And the information is available at school. These are distinctions that, though, Your Honor, that were not in the clause in Adelise. But
I take it you're saying, and my words, not yours, it's not here in clear, direct language, but you can infer it from other parts of the paragraph. Is that the argument you're attempting to present?
Correct, Your Honor.
And
when you look at the totality, you look at the breadth of the clause, you look at the disclosure of the information about the arbitration providers, the rules, you look at that, it draws the distinction between court and arbitration proceedings.
So if the standard is we were to look for clear, simple language, it's not met.
I think that the ultimate effect is it clearly comes across that there is a difference between arbitration and litigation, which I think was the goal in Adelise that the court was trying to accomplish.
But before we get to the text itself, and I'm not asking you to move away from your position that formation of the contract doesn't go to the arbitrator, but just assume that's up for grabs and it's something we need to wrestle with. The heart of this is paragraph 10, and I'm looking at the agreement 36A. I don't mean this facetiously. Can you tell us the font size?
Your Honor, the font size was not an issue that was raised below. It was raised for the first time by an amicus.
Can you tell us the font size?
I cannot tell you the font size. I
Can you
can
tell
say
us?
that the largest font that appears is right above the signature, which says this contract contains a binding arbitration provision.
I'm looking at paragraph 10, which is at the heart of our debate here. Can you tell us the number of lines that appear in this paragraph without breaks?
I could if I
You'd have to count it rather slowly.
started counting.
I tried to do it. It's 49. Would you say that this language, set aside the meaning of the words, is easy for the average consumer to read?
Yes, I think that sets it in very clear language
No,
explains.
I'm talking about ability to actually read, not the clarity of the words themselves, the meaning of the words.
Yeah, and this is a 4-page agreement. Another distinction with Adelaide's was it was, I think, a 30-something page document, and the arbitration clause was
However
put
many-
somewhere in the middle of it. This is only a 4-page document.
However many pages it is, doesn't this look like the quintessential fine print that we speak about?
No, Your Honor, because it's disclosed numerous times that above the signature, and it instructs the student on the bottom, be sure to read all pages of the agreement, they're all part of your contract. It says page blank of 4, so it indicates it's a 4-page document, and it's only a 4-page agreement. I mean, the language is clear, it's unambiguous, it's only a 4-page document, and it readily conveys that disputes are going to be resolved by arbitration, and arbitration is different than court.
I'm not going to ask you to do this, but to demonstrate how difficult or easy it is to read, if I were to say to you, can you read to us what's on line 26, it would take you quite some time to even find it, right?
I would have to work my way down.
Would you say this is easily readable? Or would you concede that it's not easily readable?
I think it's easily readable. I think it's easily readable. And I think, again, another distinction with Adelaide's, it's a 4-page agreement.
If it
That's
weren't,
what we're talking about here.
if it weren't easily readable, what does that tell us with regard to formation of contract questions?
Our position in this case, Your Honor, is the appellate division got it right, so that you got to look at the delegation provision. If you're going to make an argument about whether or not it's easily readable, it had to be made specifically targeting the delegation provision, not the agreement as a whole, not the arbitration provision specifically. That was never done.
Can we follow up on that, Chief?
Please.
Can we follow up on that? Because the argument's being made on the other side that when you consider the context of Rent-A-Center and how much was agreed to in Rent-A-Center, then the specific attack on the delegation provision means a heck of a lot more, in the sense that it stipulated there was a contract, and there really was stipulated there was some level of arbitration agreement, and there has to be a targeted attack on that delegation provision. You can see the sense of that, because otherwise the court doesn't have the ability to, or whomever doesn't have the ability to know that is in dispute unless there's a specific attack. Now, in this case, the first and really second steps that had happened in Rent-A-Center appear not to have been made, in the sense that there's no agreement as to whether a contract was even formed here. So when you say there has to be, you and the appellate division say there has to be a specific attack on the delegation provision, why isn't it enough that the plaintiff here, Mr. O'Shea and his clients, attack the whole contract?
Because an attack on the whole contract goes to the arbitrator. That type of argument,
So if we
under
accept that-
starting with Prima Paint and a whole Supreme Court line
So
of
if we
precedent,
accept that,
goes to the arbitrator.
if we accept that, Adelaide's is meaningless. Whether you agree to arbitrate, don't agree to arbitrate, regardless of what the language is in the arbitration clause, if there is a delegation clause, even if it's in small font and a 3 or 4 page document, that if it was another font might be 20 pages, I don't know. But just because there's that delegation clause, what Adelaide says doesn't matter.
No, Your Honor. What happens is the delegation clause is enforced, the matter goes to the arbitrator,
No,
and all these
okay.
arguments can be presented,
Time out.
including Adelaide's.
Including Adelaide. So you're
Adelaide.
saying,
Yeah, so-
you're saying the
yeah.
arbitrator would apply state law to the question of formation?
And Adelaide's-
Arbitrability, if they want to argue that the Consumer Fraud Act claim is
But Adelaide's would
outside
be,
the scope.
hang on, Adelaide's would be the standard, but the holding in Adelaide's that goes, it takes it out of arbitration, goes to the court, would not be the ruling.
They would be able to present their argument, right? Their Adelaide's argument, and as I understand Adelaide's, is directed at an arbitration
yes.
agreement generally. It's not a delegation clause doctrine, it's an arbitration agreement generally. So the matter would go to the arbitrator, and they would be able to present all of their objections, including the argument that this arbitration agreement is not enforceable because it doesn't comply
So
with
your
Adelaide's.
answer is yes, the holding in Adelaide's, that arbitration clause is invalid, and the claims go to the court, is no longer the holding in your situation.
It's the same holding, it's just who decides it? Does the arbitrator decide it, or
We're
does the court
talking-
decide it?
We're
And-
talking
Well,
again.
I think,
What
no,
you're
you're,
basically
you're,
saying
you're,
is that you don't have to, you could have a 20-page document, forget about this forum, same font, this delegation clause, don't mention anything about a judicial forum, and you'll say Adelaide's doesn't apply. Even though Adelaide's says that the waiver of rights language, however, must be clear and unambiguous, that is, the parties must know that there is a distinction between resolving a dispute in arbitration and in a judicial forum.
It's not a question of Adelaide's doesn't apply. It's a question of who decides whether Adelaide's was complied with. So if you have a valid delegation clause, the arbitrator decides whether Adelaide's was validly
Unless,
complied with.
we're dealing with the formation of a contract. Are you saying that with the delegation of a clause, with this delegation clause, even if there wasn't a contract formed, it still goes? There was no meeting of the minds, even for this, for any part of the arbitration agreement, including the delegation clause, that the arbitrator gets to decide the issue then?
Yes, the arbitrator decides the issue. Because if there's a delegation clause, if it's clear and unmistakable language that the parties, that indicates a manifestation of intent that the parties are going to have
Let's
the
assume
arbitrator
it
decide
wasn't
the issue.
clear. But since we're saying that it's no meeting of the minds, then it couldn't be clear and unmistakable.
But the clear goes to the delegation clause, not to some broader view of the contract or a broader view of the arbitration clause as a whole.
You're
That's what
saying that the
Rent-A-Center
key
says.
issue is there a clear and unambiguous arbitration, delegation clause? If there is, then challenges to the overall arbitration agreement, the scope of the arbitration agreement, go to the arbitrator. If there isn't, they go to the court.
Overall formation issues go to the arbitrator. Attacks on the arbitration provision, if there's a problem with the treble damages, attorney's fees, those go to the arbitrator. If there's an argument under Adelaide's that the arbitration clause is not enforceable because it doesn't comply with Adelaide's, the arbitrator will
I hear
rule.
what you're saying, but if what you're saying is true, I don't understand what section, what footnote 2 in that Rent-A-Center opinion means. I understand what you're saying, but I don't see it squaring with that footnote.
Your Honor, I think that in Rent-A-Center, again, the court made clear that the focus in dealing with the delegation provision is you've got to look at that provision specifically. You don't get to validity, and validity is something that you get to at arbitration. And the role of the court is there clear and unmistakable evidence based on the text of the arbitration, of the delegation clause, that the parties agreed to commit this dispute to arbitration. That's the inquiry. Unless there's specific attacks directed towards the delegation clause, which never happened in this case.
And the clause that we should test for clear and unmistakable language appears in subsection 5?
Yes, Your Honor.
And the clear and unmistakable, well, the only language really is, shall be resolved pursuant to this paragraph.
Well, it would be any it would start with any disputes, claims, or controversies arising out of, relating to any objection, arbitrability, or the existence, scope, validity, or enforceability of this arbitration agreement.
Right. But what do we do with that?
So
The next few words tell us that the clarity and unmistakability depends on that final clause, right?
you would be evaluating the language of that delegation clause to determine that whether it's clear and unmistakable evidence of the party's intent to commit those issues to the arbitrator. And, Your Honor, the appellate division noted in its decision that this language mimics the rules from the American Arbitration Association. So in the AAA rules, they provide, consistent with this language, that the arbitrator decides arbitrability issues and any dispute about the existence or scope or enforceability of an arbitration provision. Federal courts of appeals almost universally find that if you have an arbitration clause that says, this agreement will be disputes will be resolved by binding arbitration, and the American Association rules will govern. So there's no express delegation clause. Almost every court of appeals that's addressed the issue has said that constitutes clear and unmistakable
But many
evidence.
of those are, many of these arbitration agreements, and I've seen them in court cases, actually have language that we suggested would be approved under Attlees, explaining that going to arbitration means that you're foregoing a judicial remedy. Many of those. They may have that language in, but they have the language explaining what arbitration is. Right? Am I correct about that?
Again, an argument as to Attlees can be presented by the plaintiffs to the arbitrator. The federal courts, though, when you're talking about what is this clear and unmistakable hurdle, okay, just a bare reference of AAA rules, federal courts of appeals almost, and we cited them in our briefs, say that constitutes clear and unmistakable evidence that the parties agreed to arbitrate arbitrability.
Has this language been, since it's AAA standard language, has this language been dealt with specifically by a federal court?
It's dealt with in that you don't even need to. This case goes much further because we have an express delegation clause, as in Rent Center. It's right in the agreement. But federal courts just say in your arbitration clause, AAA rules apply. Then the who decides question, arbitrability goes to the arbitrator, just based on that.
There's no case that deals specifically with the language that appears in this agreement.
Particularly post-Rent-A-Center.
Not that I'm aware.
That's what I'm looking for, is whether somebody has some federal court of appeals or even district court has considered what Rent-A-Center meant in terms of its division of who decides what in the context of this language.
I think, though, the federal case law stands for the principle that this language, by being included in the AAA rules, and then just a bare reference to the AAA rules, means clear and unmistakable evidence.
But there's much more than that, of course, here. So that's not the case in front of us. We need to look at the rest of the paragraph, because that's what the text tells us. Can you address the references to litigation and tribunal of competent jurisdiction?
So in the class and consolidated actions, I do see the reference to litigation. I think the overall context of this arbitration clause makes clear that disputes that a student may have are going to be resolved in arbitration. There is language in this section because at times, as we know, despite having an arbitration clause, some matters wind up in court, whereas and there could be a dispute about arbitration, and this class actions are one of those areas that typically would wind up in that setting, but it doesn't create any ambiguity about.
You're saying this is telling folks that if in fact they have an individual claim, they can't both arbitrate and then be part of a class action elsewhere? Is that?
I think it's just broadly stating that there's going to be no class treatment for claims, and it references both of them. But I don't think it injects any sort of ambiguity into an ordinary student's understanding that any disputes that they may have with the school must be resolved through arbitration.
Is there anything else you'd like to add?
That's all I have, Your Honor. Thank you all very much.
Thank you. Mr. Miller.
Thank you, Your Honors, for granting me time before the court to argue. And I want to pick up by saying that I don't think this case, after having listened to very able counsel argue both sides, I don't think this case is the vehicle for the court to address the issues that it's been discussing here today. The issues are very interesting from an academic perspective. I can see exactly where the justices are going in light of Adelise, but I don't think the arguments were made at the trial court and then even at the appellate court and then even in the briefs before this court that the court is really getting at, which is how does rent-a-center not control, which I think is the argument the counsel is making, and I think the justices recognize has a good, likely does control the situation. And the reason why rent-a-center does control is because counsel for the plaintiffs, not the plaintiffs themselves, but counsel never made the arguments that the justices are ably making here today. The arguments that counsel made from the beginning, I'm going to read from my brief, which I didn't intend to do, but I think I have no choice to in light of the way argument has gone, have always been about attacking the agreement in toto. They never focused on the delegability issue to the extent that counsel for the plaintiffs has never even cited to rent-a-center in any of their briefs. In the trial court, they made 4 arguments in their motion to opposition to the motion to compel arbitration. They argued that enrollment agreements are presumptively voidable, that the contract was simply a contract of adhesion that was reached under the influence of fraud, imposition, or mistake. The defendants violated fiduciary duties to the plaintiffs by asking them to sign a contract for services, and the agreement to arbitrate was generally unconscionable. All of those arguments presuppose the position of the defendant and basically agree to the position of the defendant that there was an agreement reached, and once there was an agreement reached, rent-a-center says you go to arbitration.
So can I just see if I understand your argument?
Yes.
Your argument is not simply that the plaintiff did not specifically challenge the delegation clause, but that the plaintiff never challenged the overall existence of a contract before they got here.
They always were attacking the agreement in general and never the delegability issue, which they were on notice of, rent-a-center having been decided in 2010.
But am I correct that what your argument is I'm not saying that they never challenged the meeting of the minds below?
I just read the 4 arguments, and to me all those arguments are conceding they signed this agreement. The signature on the agreement is a sign in our society that we are agreeing to what's here. And then they say, but now we're unhappy with that result and we're saying it was unconscionable.
Well, Adelise was decided after the appellate division had rendered its decision, correct? You could take it from me that it did.
Yes, sir.
By a couple weeks.
Okay.
Does that enter into the equation? That the parties could then afterwards rely on Adelise in arguing that based on Adelise looking at this arbitration agreement, there wasn't even a meeting of the minds for the formation of a contract?
I would argue, Your Honor, that in our system we have the Congress, we have the New Jersey Legislature, we have the U.S. Supreme Court, and we have the New Jersey Supreme Court. And these laws all work together, and we each have to fit together. And ultimately, the Supreme Court of the United States is...
They're higher than us.
Yes, Your Honor. Thank you. And well, they certainly can rely on Adelise. Adelise has to be fit in somewhere.
Right.
And Adelise has to be fit in, ultimately, as the court said, rent-a-center is ultimately higher than Adelise, notwithstanding the fact that the court did deny review of Adelise, the Supreme Court of the United States. But we can't read too much into that. We just know that rent-a-center is out there, Adelise is also out there, and how do they work together? And ultimately, I think counsel for Sanford Brown has it right that when you don't challenge that delegability clause under rent-a-center, but rather you agree there was an agreement, you then are acceding to the control of rent-a-center. And you can then argue Adelise to the arbitrator, as counsel said. And I want to make one sub-point to your honors. You made a comment about the arbitration agreement here, perhaps taking away rights that the Consumer Fraud Act gives the plaintiffs. But if I understand right, from Adelise noted it, even you noted it, Your Honor, in a footnote, that under the Delta, I keep wanting to say Delta Faucet case, but the Delta funding case, any of those statutory rights would still be protected in the arbitration, because arbitration, and that gets at the public policy arguments that I really wanted to make before I listened to a good hour of arguments, which is arbitration can vindicate the rights that the plaintiffs have. It's not a question.
It's interesting you mentioned that. We had counsel here yesterday who were saying that maybe the parties could even waive these substantive rights in a different statutory setting.
Well, Your Honor, I actually had the chance to be here yesterday, and I watched the first case. I don't know if it was the Smith case that you're referring to, but I thought the Smith case was an interesting prism to talk about the qualities that arbitration have, because to me, this case has been set up in a way that arbitration is all bad, at this case today, and the courts, the rights of the jury is all good. But really,
so let me say this. Yes. So I heard that as far as I'm concerned, that's not the issue, because we have said that arbitration is a good way of resolving disputes. So this court has no hostility towards arbitration. Arbitration is a favored form of resolving disputes. But the question, I think, here is whether or not there was the formation of a contract, whether there was a meeting of the minds that there should be arbitration. Not whether arbitration is good or bad. We're not making any value judgment on that. And in fact, the value judgment would be that it's good.
And the point I was going to make with the Smith case, and I'll come back to that, is it's 10 years on, and Mr. Smith still hasn't got that first case yesterday. He has his discrimination claim. 10 years on, he's never had a jury make a decision on this case. He had a judge who may or may not have been an expert in his area take it away. And I thought that was an interesting way to look at arbitration. If he had agreed to arbitration 10 years ago, he would have maybe had his rights vindicated and had moved on with his life. But instead, he still hasn't even gotten to a fact finder. But to your point, Your Honor, I would say that whether the arbitration, whether there was a meeting of the minds here, notwithstanding whether counsel could have raised Adelise because Adelise was decided after, but the arguments all along have been to concede that there was an agreement. And that's why I would suggest this is not the right vehicle for the court to be addressing these very interesting intellectual issues.
That's a helpful point, and I mean that. Could you nonetheless tell us your position on formation of contract questions and the meaning of footnotes 1 and 2 in Rent-a-Center?
I would go to where your Justice said, are we getting lost in the trees? I was actually thinking lost in the weeds when you said lost in the trees. I think that the real holding of what's being addressed in Rent-a-Center is how did the parties attack the agreement? And the issues as to the footnotes are interesting dicta, but the bottom line is, are we attacking the agreement to arbitrate, the delegability agreement, or are we attacking the agreement in toto? And here, they never attacked the delegability. The footnotes themselves, let me turn to the footnotes.
In fact, the plaintiffs have a breach of contract action, which they allege a binding agreement. Am I correct about that? I'm just looking at the complaint.
In fact, it's another point I thought of as I was sitting at the table, that it is sauce for the goose, sauce for the gander. They actually have a breach of contract claim. So which presumably is relying upon the enrollment agreement. So when the enrollment agreement works
they
for
state
them,
that the plaintiffs and defendants entered into agreement, and they put the date as February 2010. That's the same agreement, is it not?
Yes, Your Honor. So they want to pick and choose the portions of the agreement that work for them and reject the arbitration clause that doesn't work for them. But yet they never actually attacked the arbitration agreement per se. They just attacked the attack, and they asked the court to excuse them from having agreed to the contract. Your Honor, if you would Chief Justice, if you would repeat your question.
What's your interpretation of the meaning of footnotes 1 and 2 in Rent-A-Center? What does that tell us about whether questions about the formation of a contract, and assume they were properly raised, do they go to the arbitrator, do they go to a court of law?
Just bear with me, Your Honor. I'm going to get to... I think you have to step back from the footnotes and see where were the footnotes placed by Justice Scalia. Footnote 1 is this line of cases merely reflects the principle of arbitration as a matter of contract. So then he goes on to say, court should not assume that the parties agreed to arbitrate arbitrability unless there is clear and unmistakable evidence they did so. I would suggest, Your Honor, that Justice Scalia is simply elaborating on what is well understood, that if there was some lack of clarity to this agreement, or to any agreement, then certainly you could try and attack the agreement to arbitrate. But again, here, there never was a confusion about the agreement to arbitrate, and they didn't attack it. Instead, they said this agreement's not fair to us. But the court is focusing on what I would say is a different issue. It's an issue that Rent-A-Center opened up, but the plaintiffs never, Rent-A-Center addresses that applies here, but the plaintiffs never actually engaged. As to the second footnote, it again, if you look at where Justice Scalia is placing the footnote, in a line of cases neither party has asked us to overrule, we held that only the first type of challenge is relevant to a court's determination whether the arbitration agreement at issue is enforceable. And as counsel for Sanford Brown had said, these cases go all the way back to Prima Paint, which was a Third Circuit case, which I think came out of New Jersey, which didn't have any language about foregoing a right to jury trial, yet the courts there, the Third Circuit and the Supreme Court, said arbitration was proper. And so when you look at where the footnote is placed, I understand why read standing alone, the court could get hung up on the, for example, footnote 2, the issue of the agreement's validity is different from the issue whether any agreement between the parties was ever concluded. But here, whatever Justice Scalia was focusing on there, which would have been a circumstance where the party was addressing the delegability issue, that's not what we have in this case. And that's why, again, I circle back to the idea that, and I know the Chief Justice doesn't want to hear me say this again, but that this is not the case. There may be a case to extend the Adelaide holding, but this is not that case, because this case, as argued, as presented to the court, is controlled by Rent-A-Center.
Anything else you'd like to add?
No, Your Honor.
Thank you. Thank you to all counsel for the helpful arguments. We'll take the matter under advisement. Court will